23 CR 2675, State of Texas versus Adam Hanlon. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
Angela Blake.
Are you Mr. Hanlon?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hanlon, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included assault, bodily injury, family, class A.
Any objection?
No objection.
So the complainant in this case, is this complainant his wife or is this the daughter? Who is this?
Right away, you can tell this judge isn't just going to rubber stamp whatever deal gets placed in front of the court. The prosecution and defense came in expecting a simple 111-day judgment-satisfied deal, which basically means the defendant would walk away having already served the punishment. But the judge pauses everything and asks a deeper question. Does this punishment actually match what happened? And when it doesn't feel right, the judge steps in and pushes for something stronger. That moment tells you something important about this courtroom. This judge is actually paying attention.
Satisfied.
We'll accept that, Your Honor.
Right. Do y'all want to?
I can mean.
Right. All right. I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation? That's a class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find the defendant guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on Sprite? And if you add a touch of lime to it, it's so refreshing. Coca-Cola, add some lemon to it. So refreshing. That's what I do. And Cappy's has a great drink that I've tried to duplicate and I can't. It's cranberry juice with lemonade in it. And the lemonade surrounds the cranberry, but it tastes so great. So there are other things, other drinks to enjoy other than alcohol.
I understand that.
All right, sweet tea, sometimes people put too much sugar in it, but oh well. Good luck to you, okay?
Thank you.
Thanks,
You're welcome. 2018 CR 9274W, State of Texas versus Javier Zepeda. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
When the judge asks whether he's the father of the unborn child, and the defendant says he doesn't even know yet, you can almost feel the tension in the room. Because suddenly this case isn't just about a fight anymore. Now there's a child potentially involved, a relationship that's clearly falling apart, and a domestic violence conviction attached to the situation. The judge still gives him 160 days, which honestly could have been worse. But what's interesting is the judge doesn't just stop with the sentence. Instead, the judge gives him a blunt reality check about alcohol and bad decisions. It almost feels like the court is saying, this is where your life starts going off track.
Of condition number 5.
Yes, ma'am.
Court would find violation of condition number 5 true. Is there an agreement?
Your Honor, there.
Now the second case changes the tone completely. This isn't just a misdemeanor anymore. This is a probation violation, and that means the judge could legally send him to prison for up to 10 years. And this is where the defense tries to shift the narrative. They talk about heroin addiction, methadone treatment, family support, even an employer who showed up in court. The argument is pretty clear. This isn't just someone breaking the law, this is someone struggling with addiction. But the real question the judge is about to answer is whether the system has already given him enough chances.
He's a supervisor and he's a methadone user, and that's how he fights his cringes. And
And this young man is taking methadone.
So this is the question. Here's the thing. These are the answers I need to make an appropriate decision in this case. Now, even though I cannot extend you, I can find you guilty. I can give you regular probation, but there are questions that I have that need to be answered.
Yes, ma'am.
And those questions are going to be, where has he been? And what has he done on probation?
Tell the court what program.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Javier Cepeda III.
All right, off the record for a moment. Could I see the attorneys on, so where have you been?
I've been working, ma'am, and staying with a family member. I actually have 3 jobs.
All right, so you were in felony drug court
Yes, ma'am.
and you didn't do well. Felony drug court is a good program. And what I have is that you were sent to felony drug court. You were placed in ISF. You were returned back to felony drug court. And by the end of April 2020, you were testing positive for opiates and marijuana. You continued to use drugs. You were not in compliance with felony drug court outpatient treatment. And then you stopped reporting. And then you contacted your case manager. And I'm aware of all the parties in felony drug court because I used to be an attorney in felony drug court.
Yes, ma'am. I'm aware of that.
You contacted her in July 2020. You requested help.
Yes, ma'am.
So they arranged for you to go to detox, go to Center for Healthcare Services, and then be transitioned to lifetime residential treatment upon detox.
Yes, ma'am.
You entered detox, then you left detox.
Yes, ma'am.
Then a warrant was issued for you, and then you stopped communicating with felony drug court.
Yes, ma'am.
This is the moment where everything changes. When the defendant tries to explain that he was scared and mentions having a child on the way, the judge immediately stops him. Not aggressively, but very directly. Because according to the record, the system already tried to help him many times. Drug court, treatment programs, detox, second chances. And the judge points out something powerful here. The court can offer opportunities, but it can't force someone to take them seriously.
And your problem is your chances to be worked with have elapsed. There is no chance to be worked with. You're going to have to do it on your own.
When he wasn't reporting, he was taking methadone to make sure he did not go down the spiral. He was trying, and his family is here to say that they worked with him with that.
But all he had to do was pick up the phone and call felony drug court. Have you read? I'm going to read this to you. You're going to have to get the treatment on your own. I'm going to find you guilty. The only issue is how much time. The state is asking for 5 defense. What are you requesting?
3 would be fair.
Okay.
When the final sentence comes down, 3 years in prison, the judge doesn't sound angry. Instead, it sounds like someone who has already watched this situation unfold many times before. The judge even recommends a therapeutic program in prison, which shows this decision isn't just about punishment, it's about drawing a line. At some point, the system can't keep chasing someone who refuses to show up, even when help is offered. The opportunities were there. The support was there. But in the end, the responsibility to change always comes down to the person standing in that courtroom.
Yes, ma'am.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
And also, because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. If you have a child, you need to do better. You have family here who's supporting you, you need to do better.
Yes, ma'am.
You need to pick up the phone because I know felony drug court gave you the tools you need in order to stay clean and sober. It's just a matter of you using them. All right?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.